taking you on the impact of COVID-19 on businesses, their operations, transactions, contracts, particularly regarding force majeure, frustration, and FA will be leading us through the limited access to justice aspect of things. So let me just share my screen with you. I'm trying to share my screen. 1 second. Okay, got it. Hope you can all see my screen. FA, can you see it? You're muted.
Yes, I can see it. You can go on.
Okay, fantastic, fantastic. Okay, so let's get right into it then. Now, we are all currently first-hand spectators to what is now essentially history in the making. The world is shaping in so many different ways on a daily basis, and professionals and business owners alike are scrambling to ensure that their businesses and their companies are adapting seamlessly to the threats that COVID-19 has posed. The pandemic has undoubtedly affected business operations, has affected the business's abilities to fulfill contractual obligations. And I think amidst all the uncertainty currently happening, one thing that we can all agree on is that normal as we know it is probably no more, unfortunately. So today in this session, my colleague and I will be running you through what force majeure is, how it can be engaged in contracts, its consequences, where the doctrine of frustration comes in, how businesses and clients can prepare for future crises. And FA will be taking on the last part of our presentation regarding consequences of closure of courts and adoption of ADR mechanisms in light of a limited access to justice. Now, for those of you who are not legal practitioners or familiar with the terminology, a force majeure event is an occurrence that happens outside the reasonable control of parties to an agreement. So it affects the parties' abilities to fulfill contractual obligations. So essentially what a force majeure clause would do is relieve parties where it would have otherwise been considered a breach of contract. There are myriad of examples, and it really just depends on the nature of the contract being executed or being contemplated. For example, strikes, riots, wars, blackouts, insurgencies, government laws and restrictions, or natural occurrences like hurricanes, earthquakes, tornadoes, wildfire, lightning. The list is endless, it's exhaustive. It just depends on what is being contemplated. For example, the risk associated with a contract for the supply of goods will be different to the risk associated for a contract that the transaction was made based online. They would have different risks. Now, the contract for the supply of goods, for instance, won't have risks such as cyber attacks, so that would not be included in the force majeure event in that contract. So it really just depends on the contract in question. Now, it's not enough that a force majeure event has occurred. It's not enough that there's currently a pandemic. You know, if you have a contract with a client, you can't just, sit back and fold your arms and be like, my clients know that there's a pandemic going on. They know the world is on fire. I'm not going to do anything. I'm just going to self-isolate in my house. I don't want to catch coronavirus. I'm just going to sit at home. No, it's not enough. There are elements and the ingredients that you must satisfy in order to be able to rely on the force majeure clause in your contract. The first one being it must be beyond the reasonable control of the affected party. So it must be unforeseen. It must be unprecedented. You should also be able to know what exactly the specific event you're relying on is. Is it COVID-19 you're relying on, or is it the effects of COVID-19 that you're relying on? You must be able to identify it, because the remedy that's invoked, will depend on the event you're relying on, basically. Secondly, the affected party's ability to perform its obligations must have been prevented by the event. So there must be a causal link between the event and your inability to perform. It must be directly as a result of that event. So for instance, now a lot of businesses and a lot of companies may be unable to fulfill obligations because they have to self-isolate or quarantine certain staff members, or some companies may not be able to supply materials due to the restrictions and the lockdown, etc. That would be seen as a causal link, a direct effect of an indirect effect of the pandemic. Thirdly, the affected party must have taken all reasonable steps to avoid and mitigate the effects of the event. You must explore alternative means of performing. It's not enough that there's a pandemic. It's not your fault. The pandemic is directly affecting your ability. It's not enough. You have to try and see if you can still fulfill obligations. This might be through alternative sources of labor, alternative sources of supply. However, you must just be able to prove that you've tried your best. It must be impossible for you to fulfill your obligations. Unless there's an exception to this, unless you engaging alternative means of supply or labor will mean that you're breaching a contract elsewhere. Now, for instance, my good friend Tayo, he's a construction project manager. And so currently, about a week before the lockdown was announced, but by then, people countries all over the world had already started implementing closure of borders, etc. So his suppliers for things like granite and glass and marble or some types of wood, they all closed. So he had to issue notices out to all his clients, just stating, the current situation, and he would have to put a hold on construction at the moment. But he was unable to source for alternative sources of his supplies because he already had contracts with his original suppliers. He'd already paid deposits, he'd already engaged them and entered contractual commitments with them. So in that instance, if one of his clients were to take him to court for non-performance, he would be able to rely on force majeure as long as he's able to prove that he already had contractual obligations elsewhere and could not breach those contracts. Now, once it has been established that there is a force majeure event, you must also ensure that you must also consider other things. So firstly, the first and most important thing is that you cannot rely on a force majeure clause if your contract does not have it. It must be expressly stated in your contract, force majeure. It must be in black and white. You cannot imply force majeure into a contract. Common law does not allow you to imply it. It must be stated very expressly. And even when it is stated, it doesn't guarantee success of invoking it. It doesn't mean that, you will be able to rely on it. It's just a good start. You still have to ensure that other things have been satisfied. When the courts are interpreting your force majeure clause, they would usually use the rule a justem generis. If you're in law school or if you finish law school, etc., you'll be familiar with this term, and it's a rule of interpretation used by the courts, and it's a Latin phrase that means of the same kind. So they will use and see all the other events that are listed in your clause and see if the current situation applies, if the parties intended for the current situation to apply. So for instance, if your force majeure clause has words like pandemic or epidemic or plague or disease, COVID-19 would obviously be covered under that, definitely. But if it doesn't mean, it's a wrap and, there's nothing you can do about it. No, you should look out for other things, other inclusive language, like beyond the reasonable control of the parties, or including and not limited to parties, or an act of God, language that makes it seem like the parties want the list to be exhaustive. Other things that the courts will consider are the conditions the parties entered into the contract and the circumstances that have arisen. They'll compare what was the thinking behind the parties when they entered into the contract. Could they have possibly foreseen the event happening? Is it very far? Is it very remote from the circumstances that have now arisen? Another thing is that it's not enough that your contract has become more burdensome or more expensive or more difficult. You cannot say, now that the lockdown has been implemented, a lot of materials are now more expensive, things are not the same. So it's not enough for you to say, oh, the supply of marble or etc. is more expensive. I cannot do this contract. It has to be impossible. Now, the last thing, which is very important, is compliance with your notice requirement. Usually your force majeure clause will have a section or a provision that states that notice should be given as soon as the event happens. And sometimes we'll state things like, the notice should say the nature of the event, how long the affected party thinks the force majeure event would go on for, the mode in which notice should be given. So sometimes we say in writing, or it could be by email, or it could be in person. However, it depends on what the parties prefer. But if you do not comply with the notice requirement, you cannot rely on the clause. You must comply. You must issue notice where it is required to. So I thought it would be helpful to see a force majeure clause sample, because I'm a visual learner, so I think it always helps when I can actually see and put into context what is being discussed. Now, if you look at this sample, if you look at this agreement, you will see that it has very inclusive language. So it has things like including but not limited to. It has act of God. It has cannot have been reasonably foreseen. It has and other unforeseen events, I think. It doesn't have things like pandemic or epidemic, as you can see, but I think from the language in this clause, you could still rely on it in terms of what is going on right now, because the parties clearly says, or any other causes beyond the control of either of the parties. So I think COVID-19 would apply here. It has the mode in which notice should be given. So written notice, so you must be in writing. It also states that parties must mitigate as much as possible. So devote its reasonable commercial efforts to remedy the condition. It even gives a consequence. So if the event persists for more than 20 calendar days, either party may terminate this agreement. So yeah, that's that. Let's go on to the next slide. Is COVID-19 a force majeure event? Now, it's very likely that a lot of parties that are unable to perform at the moment will invoke or say or use an act of God as a defense for not being able, for non-performance. It's debatable, and it really just depends on how your force majeure clause has been phrased. Has it been phrased in such a way for things like COVID-19 to be considered or constituted an act of God? It really just depends. Sometimes, usually an act of God is usually like a natural disaster, so an earthquake, a tornado, a hurricane. I don't know if COVID-19 falls under that, but like I said, it depends on the clause. In an American case, Langham Hill Petroleum and Southern Hills, the court in that case ruled that, sorry, one second. The court in that case ruled that the dramatic drop in the world oil prices and an economic crisis could not be constituted as an act of God, and so could not trigger a force majeure clause in an oil purchase agreement. The judge in that case stated that you cannot rely on a force majeure clause, or a party cannot use a force majeure clause to protect them from the normal risk of a contract. So it really just depends on that particular contract. What does it state, basically? But even if it's not an act of God, it doesn't mean you cannot rely on it, because other things like the quarantine, the global lockdown, self-isolation, no large gatherings, restriction of movement, flights and borders are blocked. So all those things will constitute a force majeure agreement. A force majeure event. It doesn't matter that it's not an act of God, because all those things are unprecedented and will definitely affect your ability to perform. There's several consequences that can happen when a force majeure clause is triggered, and it really just depends on what it states in the contract. So for example, like the clause that we just saw, the consequence of a claim for force majeure is termination. But a lot of the time it wouldn't be. It just depends on the nature of the contract. Sometimes the affected party will be entitled to an extension of time or a suspension of performance for the duration of the force majeure event and to the extent that you're affected. Or sometimes the affected party will be entitled to or be excused from performance in whole or in part. It just depends on the nature of the agreement. So for instance, if I have a contract to operate on an oil block and I've had this contract for 20 years, that wouldn't make a lot of sense to terminate because of COVID-19. It would make more sense to be entitled to an extension of time or suspension of performance for the duration of COVID-19. So it really just depends. Okay, now doctrine of frustration. Frustration basically is invoked when your contract is conspicuously silent on force majeure. So it doesn't include a clause for force majeure, a provision for force majeure at all. This is where frustration comes in. So frustration is an event or occurrence that happens and renders performance physically and commercially impossible. Or it will render performance radically different to what was originally contemplated by the parties. Their elements to establish frustration are a lot stricter than force majeure for obvious reasons, because frustration is a common law doctrine, so there's a very high bar invocation for it. Firstly, like we said, the agreement must not include a force majeure clause or any language to that degree. The underlying event must not be the fault of either of the parties. The circumstances surrounding the event must be after the execution of the agreement, and it must be physically and commercially impossible to fulfill the contract, or the obligation must become radically different to what was initially contemplated by the parties. Now, the reason why frustration has a very high bar invocation is because of its consequences. It's a lot more radical than that of force majeure. A successful claim for frustration results in an automatic termination of the contract by operation of law. So the parties will be relieved of all their future obligations under that contract. Hence why it's very serious. There's a very high bar invocation for it. Frustration under COVID-19. Now, any rights that have accrued before COVID-19 will remain enforceable, while any rights that have not accrued as at the date of COVID-19 will not be enforceable. Sorry, any rights that accrued before will be enforceable. So for instance, if I had a contract for the supply of some mangoes in February and I defaulted, I think by then the virus hadn't had a very huge outbreak here in Nigeria, I won't be able to rely on frustration as my defense, because the rights had already accrued before the frustrating event had occurred. Whereas if I executed that same contract in February for the supply of goods, let's say this week, the rights would be said not to have accrued, and I'll be able to rely on frustration, and it will not be enforceable even after the contract has been terminated. There are not that many Nigerian case laws on force majeure, but they are on frustration. I think the reason for that is we haven't had that many unprecedented events. And even if we have in several regions around Nigeria, I think it's likely that the parties would have probably settled out of court or found a way to amicably resolve it. But we do have quite a bit on frustration. In particular, a case I found that was really interesting was Araka and Monye Construction Co. So the case concerned, Araka was the landlord and he leased his property in Port Harcourt to Majeure Construction Co., one of their engineers, and that engineer was an expatriate. And then during the Biafran War in June 1967, the Biafran rebels ordered that all the expatriates should leave the area. So the expatriate had to leave. And then Araka took Majeure Construction Co. to court, stating that they owe him rent for the period between 1967 and 1970. Majeure Construction Co. relied on frustration and stated they can't be liable because the tenancy had been frustrated by the actions of the Biafran rebels. The case went to the Supreme Court, and the judge in that case stated that it would be unfair to make Majeure Construction Co. pay rent for a lease that they hadn't enjoyed the benefits of. And he deemed that their contract had been indeed frustrated by the actions of the Biafran rebels. So in that case, the appeal was dismissed. It's very interesting to see force majeure notices being issued all across the world, not just here. In China, on the 30th of January this year, the China Council for the Promotion of International Trade said it would be issuing force majeure certificates to companies and businesses that have been affected by the pandemic in order to help them in case counterparties want to sue them for non-performance. But these certificates are literally just evidentiary support. The other elements of force majeure that we have discussed will need to still be satisfied. In India, about 25% of companies in the energy sector have now issued force majeure notices, a lot of big companies there. In Malaysia, banks like HSBC have offered liquidity reliefs to businesses and companies affected by the pandemic. So in the forms of moratoriums, in the form of repayment, flexibility, in the form of extension on trade loans. And in Nigeria, I think about 10 days ago, on April 4th, Shell Petroleum declared that it would be relying on force majeure for its Forcados crude. It stated that operations have ceased on that pipeline, it's Trans-Forcados pipeline, which is particularly interesting because that pipeline is one of Nigeria's biggest main crude oil terminals, and it produces about 240,000 barrels of crude per day. But we're not certain that it was because of COVID-19. That has not been determined, but yeah, it's still quite interesting. Now you all be wondering, what can I do now? How can I protect myself? Firstly, review your contract. What does it state about force majeure? What is the definition of force majeure under your agreement? Does the definition allow for events like COVID-19 to be covered under it? So look through it, review it, and it might not just be in your force majeure clause, it can be the general language of your contract if it allows for events like this to alleviate you from liability. Secondly, determine the steps your business is taking. What is your business doing? Are you finding alternative sources of labor, alternative sources of material? And also jot them down. You must document as you go along so that if another party or the counterparty takes you to court, you can say, these are the steps that we took. These are the things that we tried to do, and we literally could not. It was literally impossible. Determine what aspect of the contract you are unable to fulfill. So is it the entire contract? It might not necessarily be that your entire contract is affected by COVID-19. It could be part of it. There could be parts that you could still perform. Determine what aspects and liaise with your client on whether you would still be going ahead. Ensure that notice provisions within the force majeure clause are complied with. If you do not comply with your notice provisions, you will not be able to rely on force majeure. So you must ensure that you issue your notices in the mode prescribed. You must issue it within the time prescribed so that when the time comes, or if you are taken to court, you can prove and ensure that you document your notices, have copies. Just make sure you have all of them down so that you can rely on them if the need be. So in conclusion, like we've already said, review your force majeure clause, review the entire contract and the circumstances that have arisen. Is it something that, taking into account the nature of your contract could be considered unprecedented? The parties affected take relevant steps to document the measures, like I already just said, to mitigate the effects of the pandemic. Ensure that force majeure claims are made very carefully. This is very important because it has very serious consequences. A wrongful claim for force majeure could lead to you being liable for a breach of contract, and it could also lead to the contract being repudiated. So it has very serious consequences. You must consider every aspect in detail. Are events like your COVID-19 covered under your insurance policies, and what conditions are required for a claim to succeed? So look at your insurance policies. Are things like COVID-19 taken into account? Our colleagues will be taking a session on insurance, I think on Thursday. So that'll be interesting for anyone that's interested in insurance. Consider amendment to your current contracts. Look at your amendment clause. Are you able to amend it right now in light of what is going on? And update your agreement templates to account for future outbreaks. So I think that right now, obviously because of everything happening, many more law firms are going to have more stringent force majeure clauses. Usually, it would be a standard template depending on the firm or depending on the contract. But now we're going to have to, take into account things like what is now happening. So, that is something that you should definitely consider. So that's all from me. My colleague Efe will be taking you on the last part of our presentation on limited access to justice. So Efe, you have the floor.
Thank you, Ajoke. That was really nice. Just to start off from where she stopped, what we have here is just to look at the effects of the COVID-19 pandemic. And just to take a step back for a minute, the WHO Director General, when he announced COVID-19 as a pandemic, had stated in his speech that the COVID-19 pandemic is not something that affects just the public health sector, but something that was going to affect all sectors across the board. And this is very interesting because the discussion as to force majeure and frustration is one that shows the effects of the pandemic on business environment. But the business environment is not just the sector that's been affected, the justice sector as well has indeed been affected. We can see that not all businesses have been affected by the COVID-19 pandemic. Obviously, internet service providers, the makers of Zoom and technological platforms are making a huge profit in these times. But even then, both businesses that are still running and those that are grounded by the result of the pandemic still require some measures, some forum to ventilate their grievances, and this is what the discussion is about. The justice sector has suffered no doubt, and this is seen across many countries, and Nigeria is not an exception. On the 6th of April, Chief Justice of Nigeria issued a directive stating that courts be closed till further notice. And even though he stated that urgent and important and essential matters be dealt with, till today we have no indication on how to access the courts for that purpose. Also, in light of the general movement restriction, it's not very practicable for that to be the case. And what we have here in effect is that a constitutional guaranteed right to access the courts is now being stifled, cannot be exercised. And this is all in line with the prophecy, let's see, or the prediction of the Director General of WHO. So in effect, what we would see for most businesses is that for those that are not functioning, even if you intend to rely on a force majeure or you intend to plead frustration, if the counterparty disagrees with your claim for frustration or force majeure, in effect have a dispute, and this in itself is a problem that requires a forum for its resolution. So, now that courts are closed, how do we resolve this? That's a very big question. And we see that in other jurisdictions, these have taken steps to ensure that it can continue to dispense justice despite the pandemic and its widespread effects. I'm very clear that in Kenya, in Uganda, in the United Kingdom, in India, courts have switched to virtual judgments to ensure that they can get justice. If I recall correctly, sometime a week ago, a justice in Kenya delivered 57 judgments and rulings through Zoom, and that's very impressive. Unfortunately, in Nigeria, we have not taken any such steps yet, and we hope that steps in this regard will be taken. That's it. America has announced that, and in the first week of May, they will be hearing 10 appeals by telephone, and this is very basic technology that can be adopted. In effect, what we see is that in reaction to the COVID-19 pandemic, governments of the world, courts have coined a phrase known as remote dispute resolution, RDR. We get more and more of this phrase every day, but under the RDR process, because RDR refers to virtual proceedings in courts and amicable forums. So what we propose is the adoption of alternative dispute resolution mechanisms, which is ADR, very popularly known. And we believe that if this is done, that parties can make some progress is going to last for. We don't know if we're going to have a further extension of lockdown. All we have is that the time when it's going to end is very, very uncertain. We don't know, do we keep waiting until courts are open? Yeah. For my next and the differences, and this is something we're very familiar with for most people who are legal practitioners. I need help moving to the next slide, if possible. So, for most people who are legal practitioners, we already this mechanisms which are now on the screen. And what we typically recommend, the best practices we use to have in the middle. These mechanisms are very important in this period because they, amongst the other advantages they also offer a very high level of procedural flexibility. And this procedural flexibility permits us to depart from the norm and adapt to all right, so hands up if it's better, just so I know everybody can hear me. All right, so
yeah, it's better now. You weren't clear before, but it's better now.
All right, thank you. So I'll just go back to ADR being our proposal basically, and this is our proposal because it offers a high level of procedural flexibility to allow you to depart from the norm and decide disputes in this times really. So what we recommend is a movement from the non-binding forms to the binding forms, which is the less adversarial forms to the most adversarial form. I will start with negotiation. In effect, just for the purpose of people who do not know these mechanisms, negotiation is effectively the two disputing parties coming together to say, this is my claim, this is your claim, and we need to find a way to amicably resolve disputes that we have. So what we see is that, and if you look at the image behind the text, you see two parties shaking hands, and that's really what it is. And there's a scale beneath that shows them tilting in a manner in which it favors both of them. Now, mediation is effectively the same. What we have in mediation is all the elements of negotiation, just that we have a neutral third party coming in to resolve the dispute, to help facilitate a settlement. And finally, we have arbitration. Arbitration is, in effect, what we will discuss mostly. Arbitration is the most similar to courts, which is why it is our focus majorly. And if you notice, if you look through it, if you look through the slides, you see that we've talked about a win-lose situation being the outcome of arbitral proceedings. So in effect, you have court procedures where you have them in a private forum where parties present their cases, usually with the aid of legal practitioners, and legal practitioners then decide them. For all the mechanisms suggested, we find procedural offerings which support the deciding of cases and deciding of disputes in this COVID-19 times. For mediation and negotiation, you can utilize emails, teleconferencing mechanisms, the Zoom platforms, and the likes. In arbitration, we have procedures which, even before the pandemic, were utilized to save time, cost, and overcome logistical constraints. Some of these are the documents procedure and virtual depositions and examination of witnesses. So I'll move to the considerations for the COVID-19 mechanisms. Somebody said you should declare force majeure on why. I just hope this gets better. Let me try and alter my microphone. All right, so let's just do a quick consideration. We're almost done. So first thing that we think everybody should do in this time, if you have a bona fide dispute you intend to resolve, is to consider the claim that you intend to present or your present case. And this applies to both pre-existing disputes and fresh disputes. So what you need to do is look at your claim. Is it arbitrable? Is it one that can be resolved by ADR? And that moves us to the suitability test. You know, there are laws that tell us what is arbitrable and what is not. In Nigeria, for instance, a tax dispute is not arbitrable by virtue of Court of Appeal decisions to that effect. The most popular one being probably Shell and FRS. And you need to consider which of these ADR choices are most suitable for your dispute to be resolved. For instance, if you do have a dispute as to whether or not the COVID-19 is a force majeure event, it's not something you can amicably resolve. If you are saying it's a force majeure event and your counterparty is saying it is not a force majeure event, what you desire and what you need in truth is a binding decision by an arbitral tribunal, in which case you should be opting for arbitration and not mediation. If instead parties have agreed to renegotiate their contract and just need to agree on the specifics, then what they can do is to opt for a negotiation, which is most likely going to work with lawyers involved, or a mediation with a third party to guide them to the resolution of the disputes. The next step is to consider technological and logistical matters. Is it feasible? You've chosen ADR, but then how can you go about making this process effective? What are you going to use? Are you going to use Zoom? Are you going to use Skype? Do you have a stable internet connection? Is your bandwidth enough, like mine? Is your microphone sound good enough? Is your video quality good enough? You have to consider all these things. And most importantly, it's also important to consider that if you're opting for an arbitration or a mediation that involves a neutral third party, you want that third party to be tech savvy, to understand not just the law, not just the process of arbitration or mediation, but also how to utilize this platforms, this technology to reach the resolution of your dispute. Also, you want to consider the legal and procedural matters, which is indeed the most important consideration that runs through all of this. For negotiation and mediation, the condition precedent to them is simply to agree to resolve the dispute by that means. You don't need to have it in writing, you can do it orally, as far as you record your settlement in writing. For arbitration, however, it's a little more tricky because for arbitration clauses to be valid in Nigeria, for an arbitration agreement to be valid in Nigeria, and indeed across many jurisdictions, you need to have your agreement or your clause in writing. So the first thing you want to ask yourself is, if I'm claiming force majeure on an existing contract, do I have an arbitration clause in that contract that I can immediately invoke? If you don't have a force majeure or an arbitration clause in your contract, what you want to do next is to ask the other party, can we enter into a submission agreement? Now, a submission agreement is an arbitration agreement entered into after the disputes, where parties both agree to proceed to arbitration in light of present circumstances. In our case, the present circumstances will be the pandemic. So what you do is you make sure the agreement is in place, then you look at what rules are applicable, what laws are applicable, and how they support hearings themselves. For most arbitration laws across jurisdictions, the tribunal is usually given a high amount of procedural flexibility. However, if you're entering into a submission agreement, you want to, in your interest, specifically state that parties intend to utilize virtual hearings and remote procedures to ensure that dispute can be resolved in light of the pandemic. This is important because although the tribunal has a high discretion, parties have the ability to agree and basically put that discretion out of place. Then finally, what we think you should do is to understand your limitations, because if you don't understand your limitations, you don't really understand what you're getting into, and we'll just be selling you dreams. So for instance, the limitations you find, and which I will speak to as well in negotiation and mediation, basically is that because they are non-binding forms, once you reach a resolution, they are typically at the end of that session or at the end of that undertaking, not binding on either party. However, what you need to do to ensure they are binding is to enter into a settlement agreement. And this is important for many reasons. A settlement agreement under common law compromises the course of action and ensures that a suit cannot be filed on the pre-existing course of action and can only be filed on the settlement agreement so long it is valid and still existing. Also, a settlement agreement gives you the perfect foundation to seek a consent judgment from a court once courts open, and you can then enforce that settlement agreement as a judgment of the courts. For arbitration, the limitation is essentially as to the compelling of parties to obey the award. So typically awards are final and binding on parties, but then what you find is that like judgment of court, you still have to, in the case of a recalcitrant party, enforce compliance with the arbitral award, in the sense that if the arbitral tribunal says that I'm entitled to $100,000, the other party decides not to pay me, I still need to be able to compel the party to comply with the terms of that award. Now, this is something that we could not ignore because you need to utilize the court's mechanisms to enforce an arbitral award. But what we do find solace in is in the fact that once an award is rendered, the merits of the arbitral award are decided forever until the arbitral award is set aside. And now you have the risk of facing application set aside arbitral awards. But what you will find is that so long you have a well-written and well-reasoned arbitral award, it is hard to set aside. And this is why we always advise parties to, in undergoing arbitral proceedings, to not just consider brilliant individuals and people who understand the law, but to consider people who understand the process and what it demands, and then people who will decide all issues presented to them, people who will consider the basic tenets of fair hearing and who will maintain independence and impartiality across the board. So once you understand these limitations, then you know exactly what you're getting into and how to prepare for it. In terms of guidance, we have a couple institutions dropping notes for parties who intend to observe or to follow these procedures. Most notably, we have the Chartered Institute of Arbitrators, the guidance notes on remote dispute resolution, something you can search up on the internet and find and read through. It's a very short document that explains all we have said today. In effect, I should also mention that for parties dealing with international clients, international counterparties, there is a Singapore Convention, which was signed last year, that allows mediated settlement to be enforced like arbitral awards across jurisdictions. It hasn't been ratified by many countries, but if perhaps your counterparty is in one of the countries that have ratified it, then you may have some luck in enforcing mediated settlements, even across the border, just the same way we enforce arbitral awards. On this note, this is where I'll leave you until we see tomorrow. I thank you for listening. Just to summarize what we've said, we recommend alternative dispute resolution proceedings. We recommend that you consider binding and non-binding disputes. We recommend that you take legal advice before doing this. Consider your claim, consider the stability of ADR, the choice of ADR, consider the tech, consider legal matters, and understand your limitations. Please, if you have questions, drop them in the group chat, the chat column, and we would answer them. Thank you so much for listening, and it's been fun having you. We have now attend to questions.
You can jot any questions you have in the chat box. I'm just going to stop sharing my screen so I can see your questions.
Look through the questions. Okay, so I can see a party, somebody has asked for the meaning of a consent judgment. So what parties have done really is what the courts have done and what the law has done is to allow parties reach a settlement and then adopt that settlement as a judgment of the courts, in the sense that it then has the same effect. And what you find is that on the one hand, when parties resolve disputes amicably, they can only rely on the contract that they have resolved on to compromise the course of action. But once you have a consent judgment, an actual case is filed, an actual decision is entered based on that terms of settlement, and it becomes a judgment of the courts that can now be enforced using the court's mechanisms. I hope that is clear enough. So in effect, it's like you get a judgment without going through rigors of a court procedure, conducting a trial and calling witnesses and having final arguments. You get a judgment by just sitting down and agreeing in the comfort of your homes, comfort of your offices.
Someone has asked, please, can you explain the difference between frustration and force majeure? That's a very good question. I thought I covered it, but let's go into it. So basically, force majeure has to be included in your contract. There must be a provision for it. There must be an express provision for force majeure in it. That's the biggest difference between force majeure and frustration. You know, force majeure has to be clearly outlined in your contract. Frustration, however, comes into play when your contract does not have any provision for force majeure. So it's completely silent on it. That is when you can rely on frustration. Another big difference between force majeure and frustration is that the consequences of frustration are final. The contract is terminated. Your obligations under that agreement will be deemed discharged, basically. But whereas with force majeure, there are different consequences. You know, you could be granted an extension of time, or whole or part performance, or suspension of obligations for the duration of the force majeure event and to the extent affected, or it could be terminated. It really just depends on what the contract states. Hence why it's a bit more flexible than frustration, because you have a guideline, you have an outline on what to follow, basically. Well, whereas with frustration, since your contract does not say anything about it, the only thing that really can happen is for it to be terminated. And the frustration will essentially make it impossible for you to even do the your obligations anyway, perform your obligations anyway. So, you know, that'll make a lot more sense. Any other questions?
Yeah, there's one here. There are a couple, but let me just take this one that asks about the difference between mediation and conciliation, and that's by Victor. Essentially, most non-binding forms of ADR are very similar, if not the same. For mediation and conciliation, they are very similar, and I dare to say they're the same. What you find is that it's a difference in the manner in which the goal of facilitating a settlement is reached. So for most people in conciliation, when they specify and try to make a distinction, they say that conciliators suggest a set.
FA? Can't hear you.
They say, I have listened to the both of you. I think you should do this. But in both cases, they are not binding. Yeah.
Okay, let's look at another question. Somebody asked, wait, I'm trying to answer the questions in sync.
Okay.
Just to make sure I don't miss anything. There are a lot of questions coming in. Sorry, guys. Let me just make sure I don't miss out your questions. Before you can enforce a force majeure event, it must be in the contract or agreement. Can this clause be implied in an agreement? Like I said, a force majeure clause cannot be implied. It must be expressly stated. There must be a provision for it. It's not uncommon for contracts not to have a force majeure clause. A lot of transactions, for maybe short transactions or small commercial transactions, will not have it. It doesn't mean that, you know, it's not a good contract or, you know, it's the end of the world. It doesn't mean that. But for you to rely on force majeure, like I said, it must be inside your contract. It must be within, outlined distinctly in your contract. Efe, do you want to take another question from your end?
I'm trying to look through. Somebody talked about the Singapore Convention And the Singapore Convention applies to mediation and not to arbitration. That's something you need to note. It was signed last year, and it seeks to ensure that mediated settlements documented in settlement agreements have the same effects as arbitral awards. So it applies to mediation and not arbitration. What I said is that not many countries have ratified it, but if you're considering mediating with a party in a different jurisdiction, you want to check if they have ratified that convention. It does strengthen your position in terms of enforcing a settlement.
Okay, someone asked, in reviewing a contract to determine if it contains a force majeure clause and it is found out that the clause is absent in the contract, what is the procedure for including in the clause? I think that would depend on your amendment provision. What does the provision for amendment state? Whatever it states there, then you would follow basically the provision that's outlined. So it really just depends on what the contract itself states. Wow, there are a lot of questions. Sorry. The first. Okay, someone asked. The first speaker mentioned that for the doctrine of frustration to apply, there shouldn't be a force majeure clause. What if there is a force majeure clause that was not drafted to include the current pandemic? Will frustration still not apply? What? For the doctrine over there, what is it that was not drafted to? Yes, I guess, sorry, you drafted the question quite weirdly, so I'm trying to understand exactly what you're asking. But if your clause does not have a force majeure clause, then yes, everybody can rely on frustration. There's no exception to what contract cannot rely on frustration. Every type of transaction can rely on frustration. I think that's what you're asking. If it's not, you can please let me know so I can understand better.
Okay, so there's a question here that talks about parties renegotiating a contract after it's been breached, and where a supervening event makes it impossible to fulfill the contract. Can the original breach be revisited? So if I understand you, there's been a breach, but parties have renegotiated to set aside that breach, basically to cater for that breach. And then there's now a supervening event that makes it impossible to fulfill the contract. And the view I take is that once you decide by any means to set aside a breach or to ignore a breach and make progress in a particular way, that agreement effectively, that renegotiation effectively settles the initial breach. It doesn't really touch on the question of frustration of force majeure, but it sort of pulls from the discussion of negotiation and mediation, because you are indeed saying we recognize that there's a breach for which you're supposed to pay damages or compensate us at least, and what we are saying we negotiate and we agree to proceed on separate terms. That in itself is a settlement of some sort, which compromises the initial course of action, like I said before.
Okay, so someone asked, can the principle of frustration be invoked where obligation arose before the pandemic and performance became impracticable due to the pandemic? So basically, if your obligation arose before the pandemic, that contract is enforceable. I mean, depending on the circumstances surrounding performance and when you were supposed to perform, if your obligation arose before the pandemic, it's enforceable and you cannot rely on the principle of frustration in that instance. Like I gave an example, if I had a contract to supply mangoes to Efemena in February and I was meant to supply him, let's say, the last week in February, for instance, and I defaulted, and a month after that, the pandemic happened, I'll be unable to rely on frustration in that instance, on frustration in that instance, or claim frustration because my obligation had already arose, the rights had already accrued, so you will not be able to rely on frustration in that instance. Whereas if I entered a contract with Efemena, for instance, for the supply of mangoes in February, but my rights accrued this week, those rights will not be enforceable. I can rely on frustration in that instance because the right had not approved until this week. Hope that answers that question. So a lot of people are asking for the slides. I believe they will be available after this. Problem at all. We'll share them with you. So what remedy do contractual parties have who did foresee COVID in their contract, especially as force majeure cannot be implied? If you could foresee COVID, I think the only person that could foresee COVID was TB Joshua. I don't think anybody could have foreseen the impact of COVID. If you can foresee COVID, if you could foresee COVID, that means you have superpowers, literally. But the whole point of force majeure and frustration is for events that cannot be foreseen, for unprecedented events. So in that instance, you really can't rely on force majeure and invoke frustration for something that you could foresee. You would be liable. You have to, if there's something you could foresee, you should also have included it within your contract. If there was a risk you could foresee, it should have been included within your contract as well. But you won't be able to invoke these doctrines where you could foresee and then you didn't perform. You know, that wouldn't really be fair, and that wouldn't make any sense for the other party who has rights under the contract with you too. Okay.
Somebody asked about the wrongful effect of force majeure, Ajoke.
I didn't really get the
wrongful claim.
So basically, a wrongful claim for force majeure, if you haven't satisfied all the requirements for force majeure. Say, for instance, you didn't comply with the notice requirement and you claim force majeure. That is a wrongful claim, and you'll be liable to a breach of contract. The courts will not allow for you to use frustration or protect yourself with force majeure to relieve yourself of liability. So that's why I said you have to be very careful and examine your contract and all your actions very well. Document everything that you're doing to mitigate the effects of the pandemic. Make sure that you have them stored somewhere. So when the time comes, or if suits are initiated against you, you are able to prove, you're able to show that you did all you could and it was literally impossible, because the burden of proof rests on the party alleging the force majeure claim. So the affected party has the burden of proof to prove that he was unable to perform due to the pandemic. I hope that is clear. If it's not, you can let me know. I hope that explains it.
Okay, so I think we should take just the last two questions, one by Ibrahim and the one by Charles. So I'll answer Ibrahim's question and Ajoke can take Charles' question. Is that fine? Okay, yes, so on Ibrahim's question, Ibrahim is asking how the courts should entertain urgent non-arbitrable matters, e.g. fundamental human rights claims or bail hearings, taking into consideration need to prevent the spread. His emphasis on the courts. It's a discussion we've been having at the firm, and what we really think is that it's not very difficult. You see, when the British courts and the Indian courts adopted these Zoom platforms and teleconferencing options to deliver judgments and hear cases, people said they were advanced countries. But when we have Uganda and Kenya doing these things, it tells us that there's nothing that they're doing that we cannot do. And it just takes a little bit of sorting out. And for bail hearings where you don't have to already examine witnesses, we see no reason why you cannot file process electronically and why you cannot take arguments and conduct hearing through a phone line. We understand that there's a problem of the constitutional requirement for public hearings, but what we find is that it's very simple to have audio feeds linked to the press, and the press can then disseminate to everyone live in real time. And this is what's being done by the Supreme Court in America in the first week of May, where they're dealing with 10 contentious appeals. So we don't see any reason why you cannot take advantage of these platforms to ensure that proceedings continue in urgent, non-arbitrable matters. Indeed, in all matters, to be honest, because you can use Zoom. The way we have everybody here on Zoom, you can use teleconferencing options, and you can still achieve the justice of each of those cases. I think that is our collective suggestion. So, Ajoke.
Okay, so the last question from Charles. What if the obligation arose before the pandemic, but the performance of the contract is to continue for a long time? Assuming the COVID-19 pandemic stalls it in the middle, in brackets, assuming the pandemic continues for a long time, can force majeure still be relied on? I think in that instance, it can, obviously because the contract is long-term. Like I said before, I gave the example of if I was operating on an oil block and I had been operating on that oil block for 20 years and the pandemic broke, it wouldn't make sense for you to terminate the contract in that instance. And I could still rely on force majeure, but in that instance, do you really want to rely on force majeure if the contract is going to continue for a long time? Surely you want to preserve the contract and preserve the relationship. It's very important that you're very careful before you issue a notice for force majeure. It means you don't want to carry on with the event. Carry on with your obligations. It means you want to either terminate or you want to extend or etc. Yes, you can rely on it if in that instance, and it could just mean that you'll be granted a delay in performance. You'll be allowed to an extension of time, or you'll be allowed to perform, like I said, but just try as much as possible to go through very carefully the situation, your contract, review your contract very stringently, get a lawyer to review it with you before you now start issuing notices for force majeure. Because obviously it depends on the contract what remedy will be invoked. The remedies can be quite serious. It can lead to termination. So in that instance, I would suggest, yeah, you can rely on it, but just be careful, basically. Review as much as possible. I think that's all we're taking now. Tomorrow, our colleagues, Chiamaka and Diron, right? Chiamaka and Diron will be giving you a session on remote work, data privacy, and employment relations tomorrow. So please join us and hope you enjoyed and hope it was helpful. I will be sharing the slides.
Go on. Before you move, I wanted to highlight a message from Mr. Candy Johnson. He says here, in relation to Ibrahim's question, that 60 to 70% of our court work is motions. There is no reason for oral hearings in most motions. Time can be limited even for oral submissions in the exceptional case where required. That's from Mr. Yemi Candy Johnson, our senior partner. So yeah, essentially. So you can round up, Ajoke.
So thank you very much, guys. Thank you. This was so much fun, and hope you all sign in tomorrow. And thank you. The slides will be shared with you. I believe you all dropped your emails, so we'll be sending you all the slides and anything else. If you have any questions, I did put my email address in the last slide. I don't know if you caught it, but you'll see it when we share the slides. So just send us an email if you have any other questions that weren't answered or you weren't able to get answers, and we'll be very happy to help you. So thank you so much. Thank you, everybody. Thank you.